From supplementary list, item number 1.
About this matter relates to traffic, Shillong traffic.
Yes.
Well, for the last 2 years, the case is pending and no concrete step is visible. No concrete step has been taken by the government. Even last 2 weeks back, in the midst of the school hour, one biker and dashed the young students. And the young student was flew 4-5 meters, seriously injured. Well, traffic congestion is increasing day by day, and they are filing report one after another.
Not being taken seriously. It's a problem, and the government doesn't appear to be serious about it. We don't know which area the government is focusing actually. We don't see it.
Yeah, Lordship, the
Power, no. Traffic, no. Healthcare is poor. Education is the least said the better. Then what is the government focusing on? Tell us one area where
Indeed, Lordship.
things are happening, things are developing.
The Lordship's concern is very valid, Lordship. But Lordship
Concern is not for us, concern is
Absolutely,
for
Lordship.
the general citizens.
Lordship, time and again, at least we are bringing to the notice of the court the reports. Then
And now all that you're doing is you're playing for time.
No, Lordship. We have filed a report on 22nd August, the last report. And on that day, this matter could not be considered because Honorable Justice Bhattacharjee was part of the. So matter was adjourned that. And that was the last report on 22nd August. It's a slightly a comprehensive report, Lordship. Steps in furtherance of easing it has been done.
In several areas, this court has expressed concern not only because the situation is alarming, but also at the lack of enthusiasm on the part of the state to deal with the problem. Full stop. Traffic congestion in Shillong is, possibly, number 1 on the list. Paragraph. For more than a year, meetings have been held, reports have been filed, some measures have been suggested, but there has been no change on the roads, no change on the ground. Semicolon, indeed, it worsens on a daily basis. Full stop. Paragraph. It is now par for the course that if one has to exit Shillong to take a flight from either Umroi or Guwahati, more than an hour has to be kept in hand to negotiate just the Shillong part of the traffic. Full stop. in the afternoons, when most schools give over, traffic in the central part of the capital city comes to a standstill. Full stop. The situation improved late in the afternoon, but by 5, it is the same. By 5 p.m., it is the same story. Full stop. Paragraph, though the state had bandied a report obtained from an international agency and, at the behest of this court, IIM Shillong was also requested to look into the matter, and the workshop convened, nothing seems to have come of it. Full stop. Even worse, vendors have spilled on the streets and make pedestrian travel impossible. On the sidewalks or on the footpaths. And pedestrians jostle with vehicles on the roads. Full stop. For the elderly and the less abled, the Shillong Road is a threat to life. Paragraph, yet the government carries on as if everything is hunky-dory. Full stop. In matters of the present kind, there is only so much that a court can do. Full stop. Once the court brings a problem that requires attention, once the court draws the government's attention to a problem that has to be dealt with, it is ordinarily expected that appropriate steps would be taken. Full stop. Unfortunately, the state government has chosen to do nothing in the matter of easing traffic congestion, whether by regulating the same, creating one-way streets, or removing vendors and others who have no business to be on the streets or pavements. Full stop. There clearly is a lack of political will and leadership. Full stop. Is there anything in the report that you've done or just...
Lordship, page, if we just take Lordship to page 2.
Page 2. Will do.
No, Lordship, can
This one is dated 22nd August, Mr. Khan.
Lordship, yes.
Page 2.
It furthers to status report, Lordship. Lordship will just come to...
From only 2 students in June, the number has increased significantly. How
70
significantly? 2 has become 5.
Lordship, 70 students.
And how many school-going students are there?
Lordship, that would...
Should be close to 70,000.
so, Lordship, at least we are making some progress on that. Lordship, will see come to the next part also. Lordship.
70 out of 70,000.
Lordship, the workshop had to be conducted because there was a lot of apprehension. And Lordship will see kindly see the number of routes.
Tell us how it has been eased. You may have done a lot of things. Tell us how has the congestion been eased?
Lordship's query is very valid, Lordship. That unfortunately,
Because that is what we see. We don't care about the process.
Lordship,
That's your prerogative.
Lordship will recollect on 24th July I had made a submission that now Shillong Longstone bypass tender has been called and that has been approved by government. That is one area which
No, that is what will happen tomorrow.
Lordship.
What are we doing today?
Today, unfortunately,
What steps have we taken? Have you been to the Lightbook Press side?
Lordship, yes.
No one can walk on the roads over there.
Yes.
Lordship, we have, so far, Lime Cry is concerned, Lordship, we just see we have page 7, clause number 4. We have made this Memorial Mills Road, Lordship, one way. Again, there is so much of intersection, Lordship, so difficult. That is at page 7, internal page 6. And government is still in the experiment mode. Lordship will kindly appreciate that, the number of vehicles in the road.
Of August 22, 2023 that has been filed, speaks of 70 students in the city availing of the government the transport provided by the government. Full stop. Though the state gives itself a certificate by saying that there has been substantial progress in such regard, as the figure has increased from 2 to 70, the irrelevance of the aspect can be appreciated once it is recognized that the number of school-going students may be more than 50,000 in the city. Full stop. Paragraph. There are certain other plans indicated.
Page 8, Your Lordship, additional guards.
Creating parking space. The earliest of such projects is expected to be completed by March 2024. A comprehensive mobility plan and additional roads, comprehensive mobility plan is set to be in place but there is no effect yet on the ground. Paragraph. The state would do well to ensure that those who encroach road space and have altogether taken over the footpaths are kept at bay or relocated, so that the available roads and the footpaths may be used only by vehicles and pedestrians, respectively. Paragraph. It is hoped that some progress would have been made by the time the state reports 4 weeks hence. That covers.
But Lordship permissions might bring to Lordship a notice regarding the school bus. Now, government has spent a huge public money. Now, until the last week report, the newspaper reports, government is saying that since less response from the parents, they are contemplating to send out those buses to the district level. Now, that's my concern, my lord. My concern is what is the extent of effort made by the government to persuade, convince the school authorities and the parents? My lord, I never see my children are going to two schools. We never come across sincere effort made by the school level or the government level because of the poor response system. So my humble prayer, my lord, let the government give a report under what circumstances they are going to send out those buses. My lord, that is one thing. And second, allow me to file the appropriate application in the coming days. We will bring the latest picture of the congestion area along the, occupied by the hawkers for your lordship consideration.
That you always have that liberty. We don't have to give you express liberty.
Including the bikers, madam. We have obtained the information on the RTI also.
Yes.
Hurriedly to answer the query, Your Lordship, we have stated in page 2, Your Lordship, that engagement with parents and guardians to effect this, and second is community engagement. So parents
At what level, to what extent?
Lordship is correct.
At what level and to what extent?
At least,
and then after 2 or 3 months, you say that you diverted funds from some project over here, just as a show, and then you return the buses to that project.
Yes.
No.
After making a show of, an effort.
No, Lordship, from 3 route existing, we have enhanced it to 7 routes that we have mentioned specifically, Lordship. So there are some steps, Lordship will come back. And whatever apprehension he raises,
People suffer for those they vote. We can't do anything more than that.
but Lordship, whatever apprehension is raised, is a genuine apprehension, we'll try to address it, Lordship.
Yes.
We're grateful to him for raising the issue.
Follow the next one, please.
Item number 2.
May it please your Lordship.
Yes.
Lordship, this is a contempt petition.
Yes.
Alleges contempt of an order of 14th December.
Yes.
The paragraph that is relevant is at page 34.
Yes. Yes.
At para 11, Lordship has recorded the submissions, and at 12, Lordship has finally given the direction as regards the payments which had to be made by the respondent alleged contemptors in terms with the schedule laid down by the Honorable Court.
Yes.
While saying so, Lordship had also given us liberty to disconnect them should they fail to make the payment,
Yes.
which we have done. But over and above, in my respectful submission, Lordship, since the schedule was laid down by an order of this Honorable Court and they are in breach thereof, there would be a willful and deliberate
Very
disobedience of
well.
the...
This petition for contempt appears to be completely without basis. Paragraph. By an order dated February 14, 2022, WA number 43 of 2022 was disposed of by modifying the order impugned in the appeal in the manner indicated at paragraph 12 of the appellate order. Full stop. These paragraphs, the several subparagraphs under paragraph 12 indicated the timings of payment to be made by the respondent in the appeal. Full stop. Such directions were issued on the basis upon submission in such regard being made on behalf of the parties. Full stop. Paragraph. At paragraph 13 of the relevant order, it was expressly recorded, comma, inter alia, comma, as follows. Next line, open quote. 13 full stop. The failure to make any of the payments in terms of the foregoing clauses will entitle the appellant herein to take immediate appropriate action in accordance with law, comma, including effecting the disconnection of the power supply, comma, if so entitled. Full stop. Thus, comma, it is evident that the default clause was provided in the order itself. Full stop. It is also the submission of the petitioner herein that the power supply to the relevant unit has been disconnected. Paragraph. Ordinarily, comma, the contempt jurisdiction cannot be invoked to enforce payment. Full stop. The petitioner will be entitled to enforce its claim against the respondent in accordance with law. Full stop. Nothing in this order should prejudice the petitioner in such regard. Full stop. However, comma, the petition is completely flawed and is dismissed. However, instead of the petition, we give the number. It is completely flawed and is dismissed. Full stop. There will be no orders to cause. Yes.
Lordship, at the top of the order, where Lordship has said 14 February 22, it must be 14 December.
14 December. Thank you. 14 December.
Thank you.
Yes.
From the minutes, item number 1.
Where is madam?
She's on video, Manoj.
You are comfortable on on the virtual mode?
Yes, my lord, I'm comfortable, and more so from my side, the submissions have almost been completed, my lord.
Okay.
The respondent number 1 is supposed to argue.
Yes. And we had indicated to him.
Lordship, yes, my lord. I just wanted to inform, my lord, that on the last time, Lordship had indicated that Lordships wanted to
Yes, but just the principles we had indicated to you.
judgments.
Yeah. Judgments we won't cite. The principles are obvious.
Lordship, if I may,
That first and foremost, we told you about Madiganga,
Lordship.
which is that a magistrate who records a statement need not be brought as a witness.
Absolutely.
So if the magistrate need not be brought as a witness, so where is the question of anything? If you make a retraction, then it has to be a more wholesome retraction than this, number 1.
Lordship, yes.
Number 2, a bare retraction at the 313 stage has to be ignored.
Lordship, yes.
Because you've already, number 3 is that Section 80 of the Evidence Act
The presumption is
provides that if a thing is done by a particular officer, then there is a presumption in favor of that.
much.
So that is also there. Number 4 is that over here, number 4 is that there is nothing which stops nothing in law really that stops a co-accused statements to be taken against another co-accused. Section 30 is not a bar, 32 is not a bar. But of course, we do it with a lot of hesitation because, one would try to escape the news by blaming it on the other. Number 3, I think the provision in section 229 or so on when he accepts guilty, criminal procedure code, what is the provision? 29 or 239?
229.
229.
229. So, if one accepts guilt, then there is a provision that, trial is not necessary.
Absolutely.
Now, in this case, you did not accept guilt.
No.
All that you accepted were that the two of you were together with the victim before, immediately before, and at or about the time of his death. The investigation may have botched up everything before. But what is undeniable is, from your own statement, this comes true. Yes, a statement made under 164 has to be seen whether it is corroborated by other evidence or not. Yes, a confession has to be seen whether it's corroborated. Here, there is no confession by either of you to the commission of the offence that you are charged with. The confession is the presence, your presence with the victim just before and at the time of his death. Number 1. Number 2 is that in some of the details, particularly that detail that both of you repeat, that the shoes were taken off and you rubbed the soles to revive. Bernard did it, or the other person, Bonnie, did it, either. Both of you got nervous and you did that. That shows that both of your statements are credible. Finally, you made no attempt, apart from showing some mistake in dates, which is childish. You made no attempt to question the magistrate. There is no motive that you can attribute to the magistrate. The fact that it was the magistrate who may have, who presided over the inquest is of no relevance at all, because these are judicial officers who are disinterested. For instance, if I take as a judge your application for bail, will I be disentitled from taking up your trial, or will I be disentitled from taking up your appeal?
Absolutely not.
These are the usual course.
Not the case.
And at that point of time, this is the year 2006, was it?
Not.
There were very
less
few
number.
judicial officers in Meghalaya. This was before the Meghalaya High Court was born, and we will take judicial notice of that.
Not.
So overall, this is what we wanted to tell you. We wanted to show some, but we don't want to cite cases. They are so obvious that we don't want to cite any cases. And the final thing is that neither of you has been able to explain the payphone, that slip, which indicated that Nirvika is her name?
Nirvika.
Nirvika was called at a particular time from a particular payphone, which fits into the story quite well. All right. So there is nothing that we see stands in the way. The only thing that we had asked was to show us what the trial court relied on. I don't think that your colleague did a good job of that, or she even completed that. But that's the only thing we want to see.
Yes.
What weighed with the trial court, and so that we can point out this is where the trial court fell into error, this is where the trial court committed a mistake.
Yes.
All right. So shall we?
Lordship, if I may pray, my lord, since this has fallen, Lordship, if it can be taken up on Monday, I'll assure.
Today is what day?
Today is Wednesday, my lord. Monday, second half, if it's taken.
Monday is what is the date?
Monday would be, Lordship, 25th.
You're pushing it close. We'll take it at 2 p.m. on Monday.
Lordship, absolutely. I will not see.
We'll take it at 2 p.m. on Monday.
Lordship, absolutely. Only on these points I will.
Only on these, because the rest don't. The rest are minor points, like it wasn't the victim's mobile phone, it was Bonnie's mobile phone. Those things do not impress us. You have to sift.
Lordship, yes. The main focus is on the 164, and I'll try to, my lord.
But the only thing is that if you can convince us, your final thing is in showing how the trial court applied its mind to the matter.
Absolutely.
And if there is a possibility of looking at it from the same perspective, then again it is our duty to allow it to remain.
Lordship, yes.
That's the only place. Independently, we don't see any justification. But the approach of the trial court, if it is reasonable, and if on that basis we are also persuaded to look at it in that perspective, that's the only escape route that you have.
Absolutely, Lordship. I have to defend it on the basis of
on the basis of the trial court judge.
Absolutely. Monday, my lord, I'll.
2 p.m.
Lordship, yes.
At the request of the first respondent, let the matter stand. The two matters.
No, single matter, joint appeal.
Let the matter stand over till next week. Then, next line, the matter will appear on September 25, is it? At 2 p.m.
Yes, ma'am.
Thank you.
Thank you, Lordship.
And in the meantime, just for your benefit, you open up any textbook and you see hundreds of cases against you.
In fact,
there are several in your favor.
Lordship, yes.
There are several in your favor, which also we have seen, but they are distinguishable on facts, on peculiar facts. But what is of great importance is that a retraction cannot be willy-nilly.
No, I absolutely understand.
A retraction has to be something serious.
Lordship, yes.
You can't just say, I didn't say so.
Lordship, yes. If the circumstances don't indicate that I had a reason to retract, the retraction does not.
Exactly. Plus, the problem that you face over here, for whatever reason, we are not going into the morality of it, is that you did not make out that case with the magistrate when the magistrate was in the box.
Unfortunately, yes.
Magistrate need not have come. In that situation, you would have had to make an application for retracting your statement, whereupon the magistrate would have been called, whereupon you would have had to required to disprove. You had to disprove. You did understand the difference between prove, disprove. And that is the degree of onus on you.
Not proved will not do.
Not proved is something else. Not proved is disprove is you have to affirmatively unprove it, so to say.
Much obliged, Lordship. On Monday, we'll.
Question for unlisted matter. From supplementary list, item number 1.
May it please your lordship, this appeal has been filed against a judgment and order dated 11/4 of 2023,
11th of August,
April of 2023.
11th of April, yes.
And basically, this appeal is pertaining to the matter wherein the respondent herein was a BSNF.
Sorry?
The respondent herein was a BSF personnel. And he, while doing his course, during the time when he was in service, in 2 occasions he had overstayed from leave, and subsequently on that ground he was dismissed from service.
Have you served everybody?
No, your lordship.
The applicant will serve the respondents and
Lordship.
inform them that the matter will appear next week. Full stop. The respondent should also be informed that in the event the delay is condoned, the appeal may be taken up immediately.
Much obliged, Lord.
Tuesday. Yes.
From the main list, item number 1.
What is the matter?
My lord, this is relating to the Joy Ratachara, my lord.
Oh, this
My
one.
lord has pointed out that the road stretch is very
Have you
bad.
seen the newspaper report
Yes.
that there are going to be agitation over there?
In fact, if
My
I-
lord, what is also a problem in the area is that, my lord, during daytime in the Clariot area, my lord, work is difficult to carry on because of the traffic flow. And in the night time when people want to work, my lord, there are certain antisocial elements.
You have never told us this before.
My lord, my officers just.
It is alarming to note. This was due to appear today or it has come up at our instance?
No,
as per last order,
usually.
it is listed to the lordship.
Very well. It is a matter of serious concern that despite the contrary representations made by the National Highways Authority of India to this court in course of the previous proceedings, that the stretch of NH6 from Jawai to Ratachara is in good condition, except for a stretch except for stretches on either side of the Sonapur tunnel, the reality is otherwise. Full stop. Paragraph. For the nearly 2-kilometer stretch, as the NH6 winds through Clariot town, it may not be surprising to see local fishermen with fishing rods on the sides, waiting for a spot of rain to allow them to carry on fishing in the craters along the way. Full stop. Further down and beyond Clariot, the road almost does not exist. And there have been repeated complaints by local residents and the district administration, and even a committee of MLAs to the NHAI, but to no avail. Full stop. paragraph. The matter came to light in course of a legal awareness camp conducted last weekend near Clarion, and the locals complaining of the pitiable condition of the road right up to Ratachera. Full stop. There were also reports that a central agency has undertaken an investigation and questioned some NHAI officials and representatives of the contractor, which has resulted in NHAI taking little or no notice of such crucial stretch of road that connects the rest of the country to the Barak Valley, Tripura and Mizoram, in particular. Full stop. Paragraph. It does not appear that adequate money has been allocated to carry out the regular repair work. Full stop. It also appears that offers may have been invited for some stretches of the road with no takers or a solitary offer being received. Full stop. It would do well for the regional head of the National Highways Authority of India to personally visit the site and drive the stretch from Joai to Ratachera and file a report, both as to the condition of the road and as to the steps that would be taken immediately. Full stop. The present condition results in trucks and other vehicles regularly turning turtle or meeting with a breakdown that further impedes the flow of traffic. Full stop. Paragraph. Counsel appearing in the matter. What kind of hierarchy does the NHAI have?
My lord, the project director here in the headquarters of Shillong, and there is a maintenance manager also, my lord.
No. Who is the director in the Northeast? There must be someone responsible for the Northeast.
Northeast. I'll just get instruction.
Please. Counsel appearing for the NHAI will ensure that the highest ranking official of NHAI posted in the Northeast travels the stretch of road within the next week so that a report is filed by the end of next week. Full stop. The present condition is totally unacceptable. Monsoon or otherwise. Full stop. The matter will appear, give next Thursday's date.
If I may make a small submission, Lordship.
Yes.
Lordship may kindly come to order dated 21/6/2023.
Yes.
My Lord may kindly come to para 6. If I may read, my Lord.
Yes.
The NHI should take remedial measures and consider placing rocks and nets of buildings retaining walls on the sides of the mountain or either side of the tunnel. So, my Lord, that aspect, on 21st/6, my Lord, certain orders were passed. Even after that, nothing has been done, my Lord.
Very good.
Nothing has been done.
Just before that,
And there has been landslide,
just
my
before
Lord.
that, counsel for the NHI, before that,
My lord,
the petitioner adds that the Sonapur tunnel was too short and it was plain to see before the construction was undertaken that there would be heavy landslides at either end. Full stop. The petitioner points out that despite orders in this matter, including the one passed on June 21, 2023, no steps have been taken by the NHAI to take care of the roads, the stretches on either side of the Sonapur tunnel.
In fact, there have been, my Lord, landslide after that.
We are aware. Now we've been told, we've actually seen it. We've been shown photographs.
Lordship.
I have personally traveled that road.
my lord, they place the minutes of the meeting, my lord, which was taken place, and it also highlighted that the portals of Sonapur tunnel also needs to be addressed, my lord. This was
A copy of this order will be reached to the chairman or the highest authority of National Highways Authority of India for immediate appropriate action to be taken. Together with an explanation as to why the Northeast has to suffer such inaction.
My lord, one more thing, my lord. There was already a proposal for strengthening of the said road, my lord, from Joy to Ratachara, my lord.
Those proposals are on your table, sir.
No, my lord, it has been sent to the head office, my lord.
They've been sent to the head office. Head office has done nothing.
Nothing, my lord. That is also what I wanted to point it out.
Head office has done nothing.
Nothing.
Your office does not do anything because there is a CBI matter going on.
One more aspect, Lordship. In fact, my Lord, people being felt helpless, even the toll gates also have been shut down, Lordship, now for past 2 months. Unless they give the assurance for repairing the roads, those toll gates have been shut down, my Lord. Till
Yes.
it's shut down, my Lord.
Let us see what happens.
Lordship.
Next Thursday, we want something. And please ensure that a copy of this order reaches do you have a managing director or what do you have, a chairman?
Project director, my lord.
No, who is the head of NHAI?
My lord.
MD, Engineer.
Chairperson.
There must be a chairperson or somebody. Ensure that a copy goes there.
Yes, ma'am.
Because we'll take up proceedings in contempt thereafter.
Apologies.
Item number 2.
We'll not send him to jail. We'll ask him to spend nights over there on those roads.
Lordship, a report has been submitted, Your Lordship.
What is this about?
This is about the load shedding.
We'll close the matter. A further report has been filed by the state, a paragraph. The matter pertains to the rampant load shedding that had been resorted to in the earlier part of this summer and the petitioner's grievance that certain areas may have been more favored than others in such regard. Paragraph, since the power situation has improved and several steps have been indicated and several steps to augment power supply have been indicated, which will, naturally, take some time, the immediate grievance of the petitioner appears to have been addressed. Paragraph, Accordingly, PIL number 3 of 2023 is closed. There will be no orders to cause. Paragraph. It will be open to this petitioner or any other public-spirited citizen to refer to any deficiency in the supply of power in future, notwithstanding this order.
Lordship, only one aspect, this in the order dated 14/6/2022, where my lord has given an order that hospitals and that has to be without any interruption. That I think they are not any.
Very well.
That
where I've said disposed of with a direction that had been previously issued in these proceedings being repeated. The state government should ensure that hospitals and emergency facilities are not disrupted even for a minute due to lack of power supply. Full stop. Yes.
Pleasure.
So that, madam,
Yes, Your Lordship.
there can be accidental, but there cannot be planned load shedding in hospitals. Yes.
Item number 3.
Yes, sir.
May I please, Your Lordship? The instant appeal has been prepared against the impugned judgment and order dated 31/12/2022, passed in WPC number 128 of 2017.
Yes.
My Lord, there was a delay of 218 days, my Lord. I have prepared a miscellaneous application for condonation of delay. On the last occasion, Your Lordship was pleased to.
Very well. What is the on merits? What do you have to say?
My Lord, this impugned judgment. This is the outcome of second round of litigation. In the first round of litigation, the 1,338 employees of Assam Rifle belonging to combatant side, Your Lordship, they approached this honorable court. Specifically for two pairs, Your Lordship. One, that their entry grade should be at par with other central paramilitary forces. That is up to the rank of warrant officer, entry grade. That should be upgraded with higher pay scale of 4,600. And the second pair was that they should be given normal promotional avenues up to the rank of twice second in command, my lord, which was available in other central paramilitary forces such as BSF and CRPF. So that single bench has disposed of the matter in our favor, my lord. In our favor, then division bench also upheld with minor modification. Then the matter carried up to the Honorable Supreme Court. The Honorable Supreme Court also, with a reasoned order, upheld the judgment of the learned single judge, Your Lordship. Then, my lord, it was implemented. Both the pair were granted. We have been upgraded up to the rank of warrant officer, and the second pair that our promotion, periodic promotion, should be up to the rank of Group A officer, that is second in command. That is also, that notification also given by the Ministry of Home Affairs. But this implementation order on the next day, it was withdrawn. This promotion part, that up to the rank of
Up to 2-1C.
yes, second in 2R, that has been on the next day, Your Lordship. It was
Withdrawn. On what ground?
That was not a part of the judgment. That was not a part of the judgment. And prior to that, some communication of the Ministry of Home Affairs and Ministry of Finance, I will show Your Lordship, some documents need to be shown, because my humble submission that it is the interference with the judgment which has attained finality. Now, the learned single judge has observed that officer, Group A officer, it is not mentioned in the judgment. What is mentioned in the judgment, in the earlier judgment, that parity, to bring parity, a specific pair was there in the repetition, in the earlier repetition, that we should be given the promotion up to the second in command. That is at par with CRPF, and CRPF, that post is called assistant director, ministerial.
Assistant
Director ministerial, which is equivalent to the post of second in command in Assam Rifle. So I like to draw Your Lordship.
No, so what did the judgment say?
Judgment says that group A, nowhere it is mentioned that group A officer level, only clerical level. But prayer was there and that discussion was there in the judgment, and the specific order in para 14 of the operative part of the judgment, it is says to bring parity. Parity means in each and every cadre, parity should be there. So may I, my lord, if your lordship permit me, I'll show some documents, my lord. Some, my lord. Lordship, first of all, I like to draw your lordship attention.
The reasoning in the impugned order.
Impugned order, your lordship will find page 234 and 234 and continuation from 26 onwards, your lordship. There are 26 onwards, your lordship. That is page 26 onwards. Lordship, where my lord, learned single judge also?
Just saying. When is the order passed by the single judge? 23rd August 2012 order?
That is page 234, your lordship.
230?
234 of the writ appeal. Lordship is referring to the impugned judgment of the learned single judge.
No. Earlier order.
Earlier order. That, my lord, your lordship will find 83. Page 83. Page 83. Lordship, it started from page 83. And relevant, it is names are there.
No, it's at 114.
100, yes, my lord. Lordship will first para. Lordship got it. First para, your lordship. I'll read first para.
In the result, restitution stands disposed of with the direction to the respondent to take up the matter with the Respondent Secretary Government to bring parity in respect of rank structure and pay of Assam Rifles clerical cadre at par with other CPOs by introducing rank of Assistant Sub-Inspector, Warrant Officer at the entry grade with effect from so-and-so, in the scale of pay so-and-so, with effect from 1196, or any other date as the authority deem it fit and proper with all consequential service benefits in the light of the Government of India resolution, whole exercise will be complete. Yes, only that much.
Yes,
nothing else.
To bring parity, my lord. Parity,
maybe.
Parity is up to the rank and structure. Lordship, my humble submission is rank and structure.
No.
My lord, my humble submission, subject to your lordship's approval. Because your lordship will find, if your lordship take to page 120, para 7E, your lordship, that discussion is there. 7E, your lordship. Page 120, your lordship. In the second para. My lord, may I read it?
Yes.
As the petitioners are having similar recruitment qualification, 10+2, and performing similar nature of works, duties and responsibilities, like their counterparts in other CPOs as ASI, which is evident from Annexure 5, 7 and 8, the petitioners have acquired a valuable legal right for grant of equal rank, status and pay at the entry grade and promotional avenues for promotion up to the rank of second in command, Assistant Director, on the authority of statutory order following the 4th, 5th CPC and resolution dated 29/1997 for restructuring and to maintain parity with other CPO. Then, my lord, G also, in the next page, your lordship will find G also. The restructuring has been carried out. In our writ petition also, prayer was that we should be given a specific prayer over there. That I have put it in the appeal itself, my lord. I have put it. That specific prayer was there, my lord. The restructuring has been carried out in all central paramilitary forces to establish 1-to-1 parity with Delhi police. So, rank structure means, my lord, whatever rank structure is there in other CPO, that should be need to be made available in Assam Rifle.
G does not say anything about E is there. E is there.
And there was a specific pair in the petition before the single bench, planet single bench. Specific pair. And Supreme Court order is in details passed, page 128. Supreme Court order.
Page
128, my lord.
128.
128. Lordship got it. Radhakrishnan Nair, KM versus Union of India. Now, my lord, I'll show 3 orders of the Ministry of Home Affairs. After that, your lordship will decide. These 3 orders, my lord. This is very vital for whether it goes in my favor, my lord. Page 130, your lordship. Yes. Ministry of Home Affairs.
Just a second. Where is the... Where is the original trial court order? 23rd 8 2012.
That is page, it is started from page 83.
Page 114.
Yes, ma'am.
And the paragraph that we saw was at page 120.
120. 120.
Paragraph 14. 127. And para E at 120.
And G also, my lord. Then I want to.
G does not make any sense.
My lord. Then, lordship, my lord.
Yes. The other letters that you want to show?
Yes, my lord. Page 130, my lord.
130.
This is a Ministry of Home Affairs letter, my lord, dated 19/2/2016, your lordship. After disposal of the SLP, this first order was passed. May I read this order, my lord? This is very vital. My lord, subject. Implementation of judgment and order dated 23/8/2012 of Honorable High Court, Meghalaya Shillong Bench, passes in WBC number 277 of 2010, filed by Nayab Subedar Clerk Radhakrishnan Nair of Assam Rifles and 1,338 others versus Union of India and others. The undersigned is directed to refer to the Assam Rifle proposal on the subject cited above. As the instant case, Assam Rifle has agreed to implement the judgment and order dated 23rd August 2012 of Honorable Meghalaya High Court, Shillong Bench, passed in WBC number 277 of 2010, filed by Nayab Subedar Clerk Radhakrishnan Nair of Assam Rifle and 1,338 others versus Union of India and others by introducing the rank of warrant officer ASI as the anti-grade with effect from 1/1/86 in respect of clerical cadre enrolled prior to 29/10/2002 to bring parity in respect of pay, rank and status of Assam Rifle clerical cadre at par with other CAPFs. As regards second part of the judgment, that is very vital, my lord. As regards second part of the judgment, that is promotion avenues up to the rank of second in command at par with counterpart in different CAPFs, Assam Rifle has intimated that it is not applicable as parity in the upper line of rank structure is only up to Subedar Major in Assam Rifles. Hence, highest rank permissible to clerk will be Subedar Major, then my lord para 4. As the issue is promotion avenue up to the rank of 2IC in clerical cadre in Assam Rifle is requested to submit this issue in a separate file with adequate justification. Whether promotional avenues of clerical cadre in Assam Rifle is to be extended up to 2IC rank or restricted up to Subedar Major, implementation of one part of the judgment and order of High Court leaving other part is contradictory. They themselves admitting that if only we grant the initial rank of warrant officer, other part will remain contradictory. My lord, this order was passed on 19/2/2016. After 4 months, in June 2016, your lordship, they have implemented. They have granted the benefit of up to second in command by the Ministry of Home Affairs. That is page 131. Page 131. May I read it, my lord? Implementation of judgment and order dated. It is after 4 months, my lord. Lordship got it, page 131, my lord. I am reading it, my lord.
How did Assembly Rifles reply to this?
My lord?
How did Assembly Rifles reply to this letter of 19th February?
They said it is not a part of it. It was added by the ministry. That is next page 132. Ministry of Home Affairs reply. And next day it was withdrawn. On 21/6/2016, order was passed. And next day, 22/6/2016, this benefit of promotion up to second in command was withdrawn. There are 3 essays, it is re-examined. And it was added by Ministry of Finance.
Who is the Naib Subedar?
My lord, petitioner. Within 1 day, they have withdrawn it, implemented and withdrawn.
Yes.
So you'll see here in this 32 it is given that Ministry of Finance is given, it is not by the proposal was not by the Assam Rifle. And another aspect of the matter you will see page 221 you will see.
Yes.
You will see the order dated 10th October 1997. This is the post of rationalization of the post you will see. So this is given effect.
Yes.
An order of the specific university to give the effect of this order. This 127. This is written
157.
127 you will see. Page number 127. This is the Secretary of the Government of Finance, Ministry of Home Affairs to bring parity in respect to the structure and pay of the Assam Rifle Cadre as per with other CPUs by introducing rank of Assistant Sergeant Municipal Warrant Officer at the NT grade with effect from 1/1/86 in the pay scale of such and such with effect 1/1/1996 or any other date as the authority deemed fit. So any other date has been removed by the Supreme Court. And the Ministry of Finance resolution dated 29/1997 communicated through this MS letter dated 10/10/1997. So you will see the letter 10/10/97 is this letter, and this is the rationalization of the pay and structure. You will see given the. So this is the letter given effect, and the first letter when learned friend is referred, you will see there was mistake by the Ministry of Finance, and it has been corrected on the very next day. So there is nothing wrong in the judgment passed by the single bench.
Well, here I like to draw your lordship attention in other CRP Act up to the second in command, that page 144, commercial liability of a clerk by 144. So you wanted parity with other central paramilitary force, and that was granted by the judgment which tabled up to Supreme Court. Page 144, your lordship. Page 144. If serial number 12 in the this is letter dated of CRPF, Ministry of under the same Ministry of Home Affairs, all the central paramilitary forces, and there, my lord, from head constable to assistant director. From serial number 8 to 1, your lordship, in the descending order, it is up to assistant director, that is second in command. And that parity, and in our prayer also, before the learned single judge, in the first round of litigation, up to second in command. Prayer also I have put it in the appeal, para 14. And Supreme Court also in KK Dination case, that parity must be there. I placed the compilation of judgment, KK Dination. Page 144, your lordship. Havildar, head constable, HC ministerial to assistant director. Page 140, CRPF. The normal promotion from Habildar clerk to assistant director. OIC, page 144. For clerical grade. M means ministerial. In the bracket it is written M, my lord. M means ministerial. This is a normal promotion channel for clerical trade. And Supreme Court in KK Dination case also held that there should be a parity in each and every rank. And they have partially implemented and withdrawn. And thereafter withdrawn. And now allegation is ministry has added. To bring parity method in respect of rank and structure means each and every rank and structure. It cannot be confined up to Subedar Major. And in Assam Rifle, highest level is Subedar Major. In Assam Rifle, its highest level is Subedar Major, there is Group B. And in CRPF, VSF, it is up to Group A from clerical state. And therefore, specific direction is made after discussing the judgment, which has attained finality. And they have issued the promotion order, the implementation order. And thereafter, all of a sudden, withdrawn it without providing any opportunity.
No, they've interpreted that that has not been specifically mentioned in paragraph 14.
But to bring parity in rank and structure means each and every structure, if it is not even specified, each and every structure. Parity 1 to 1. In para G also, 7 para G also, 1 to 1 parity, that is also my lord discussed.
Your Lordship, this page 174. Paragraph B and C, Your Lordship, it will be clear. 174.
74.
174. Page number 174. Internal page 29 of the affidavit.
Yes.
This is the tabular chart is given. Paragraph B. Further, the contention of the petitioner is denied. Petitioner is unnecessarily misleading this honorable court by paying on unconfirmed information. It became the erroneous to draw a parity between the Assam Rifle and other CPOs, wherein Assam Rifle is categorized a Central Paramilitary Force, CPMF, and CRPF census fall
Where can't follow you.
This paragraph B.
Paragraph B.
Paragraph B.
Further the contention.
Yes, further the contention petitioner is denied. And it is given for the differences and distinguished by them. And then Assam Rifle in one, and then BSF, CRPF, CS, ITBF, SSB, and DSF, it is given. Number A, it is given. It is designated as a Central Paramilitary Force commanded by regular army officer. And BSF and CRPF, it is designated as Central Armed Force commanded by cadre officer of IPS officer. And then here returning age also, Your Lordship. Next, returning age of the constable is 60 years and returning age is 57 years. Then Assam Rifle Northeast Central Force, and this others is liable to be served anywhere in India. And operation control also, it is under the Ministry of Defense, and then it is in Home Affairs. And recruitment zone is done from the part of the country in proportion to the population of the state, and recruitment is done from all part of country in proportion of the state. And then Your Lordship, C, next page. Here, Your Lordship, Assam being the paramilitary force, most of the RRs and recruitment standards are at par with the army norm, which do not match with the CPF. Rank structure and CPF and Assam Rifle can be seen below. And it is given, Your Lordship, here. Your Lordship, in CPF, CPF, they are the constables, they are some constable, and in Assam Rifle, it's called Assam Rifleman. At head constable, it is equivalent to Havildar.
No, sir, we are happy that it was given.
So, you will see
Discussion at paragraph G, page 120, indicates that that has been also granted by the prayer.
So here is the recruitment process. So you will see recruitment when this done. Then also it is different assistant commandant and this coming direct recruitment. And here 80% deputation from Indian Army. So there is lots of differences, Your Lordship.
I have relied upon one judgment, KK Dination. Compilation I have given, paragraph 4, 6 and 24 will make it abundantly clear. And Assam Rifle is one of the central parliamentary reports along with others that 6-pay commission recommendation.
We'll condone the delay today, we'll keep it after some time.
My lord, if you wish.
The delay in preferring the appeal is condoned. Paragraph in view of the good ground shown. How many days?
218 days.
The prayer for condonation of delay of 218 days is allowed. MCWA number 31 of 2023 is disposed of. The writ petition will appear for final hearing for reasons. Yes, that's to be allowed.
Item number 4.
No, but he is the court also considered that favorable. Yes.
May it please, Your Lordship. My Lord, during the pendency of this petition, my Lord, grievance of the petitioner has been addressed, my Lord, and GST cancellation has been revoked, my Lord.
Very well. Thank you. Pursuant to the previous request by the court, the GST authorities have dealt with the matter appropriately. Paragraph, the petitioner does not wish to proceed with the petition. Paragraph, accordingly, WPC number 277 of 2023 is dismissed as not pressed, and without going into the merits of the matter, there will be no orders to pass.
Item number 5.
Yes. What is the writ petition directed against?
Lordship, this is against, Lordship, we are challenging the order which is passed by the Central Administrative Tribunal.
By the?
Central Administrative Tribunal.
Central Administrative Tribunal.
Yes, Lordship.
Yes.
Lordship, in this matter, Lordship, the...
Yes. How are you aggrieved by that order?
Lordship, as per the CAT order, Lordship, the petitioner, the respondent, he was being transferred.
He was transferred?
He was, yes, Lordship.
Yes.
He was being transferred. Transferred at the Shillong station, Lordship.
From where to where? Shillong to Turat.
Lordship. Lordship, and the CAT allowed this transfer order, Lordship. Lordship, the learned...
Just a second. Where is the order of transfer?
Lordship, it is in Annexure 1, page 11.
Page 11. There's no punishment.
May I please, Your Lordship?
There's no punishment.
May I please, my lord, I want to project this. First of all, this, I allege the malafide, one. The order of transfer not only under FR, although under FR 15, but the issue starts from I was posted in the center on 1st of July of 2022. And I have found that there are lots of pendings of the undistributed the postal articles. So I specifically lodged a complaint against the postmen who are not compiling the order on 9th of July. Immediate after receipt of my complaint, no action was taken against any of the postmen. And SOCOS was issued to me. I replied the SOCOS. I was not the center head. Center head was the one of the lady. Earlier, she was from earlier head.
When did you join this post?
That one on 1st of July 2022, which is at...
you joined 1st of July 2022?
22, that center. Page 48 is that.
No, center. Where is the center?
Center is that it is a postal delivery, article delivery center in the GPO itself. It's a wing.
It's in Shillong.
It's in Shillong. Then, my lord, I found that the lots of pending and the undelivered, but the postmen, 3 of the postmen, they said that we will just 50% we can clear. So I lodged the specific to take action at page 49 against the postman, addressed to the senior postmaster. Nothing has happened on my complaint against those postmen. Rather, SOCOS was issued to me that explained why this pendency. I explained in details because I joined on 1st of July. There are lots of pendency. Another lady was posted in charge of that center. So, without doing anything inquiry, I was transferred under FR 15. So, FR 15 is, my lord, there is a power of delegation of power by the Ministry of Post in the year 2019 circular letter issued. Only the Chief Postmaster General can exercise that power under FR 15. But FR 15 to implement the, utilize the FR 15 power, one has to show that he is inefficient. Surprisingly, my lord, I complained that the postmen are not working. No action was taken against any postman. I was transferred along with that lady. And who is the center in charge earlier from prior to 1st of July 2020?
Yes, according to Shillong. The tribunal has taken a view that this is malafide. For the next 3 years, he'll be in Shillong, accommodated in Shillong. Him or her. What are you,
my lord? Yes, not my lord. I have authorized the by Okalat myself.
There have to be special reasons. Administrative exigency is understood, but this appears to be malafide. And the tribunal has taken a view it's malafide. We don't want to interfere with it.
Lordship, I pray for 2 weeks' time, Lordship, if we can come prepared with this matter, Lordship. Lordship, I pray for 2 weeks' time, Lordship.
Very well. Since the petitioner seeks a fortnight's accommodation, let the matter appear 3 weeks hence.
Lordship, I also pray for stay in this matter, Lordship.
Sorry?
I also pray for stay in this matter, Lordship.
Stay? No.
No stay.
The prayer for stay is expressly refused since it is evident from the order impugned that the tribunal was convinced that the petitioner had been unfairly treated and posted out of Shillong only because out of turn only because he had complained of some other staff not discharging their duties. Full stop. Then give it a date after 3 weeks.
Deeply.
This is one matter, madam. We'll keep note of it, track of it, finish it out before we go. Before I go, that is. Because this is not a worthy matter. Once they've said it's malafide 6 years he has. You just can't say ineffective. You have to say, then throw him out. Institute disciplinary proceedings against him, throw him out.
Exactly.
But you can't do this kind of favoritism. Just remember to ensure the matter is there and completed before me.
Your pleasure.